so as to assist.
So I should just adjourn and then
No, just for a minute, Your Worship, I just wanted to step
I
aside.
wonder if I'll always go up and down.
Emma.
The court pleases recalling case number F473 of 26 State versus Charlotte Tibane and Peter Nonyane.
Witness Kutiso Tobejani, you are warned that you are standing under oath.
Kutiso Tobejani, Barigili, Mishawal, Salaka, motion. Noted,
Yes.
You testified that accused 1 and 2 went to Vonderboom Mercedes-Benz dealership. Accused number 2 was carrying a firearm, and you further testified that they arrived there, and that was the 30th of October 2024. Accused number 1 and 2 caused havoc. Can you kindly elaborate on that particular issue of causing havoc at the dealership?
Ba re jwale lena le file je file botlhatsi ba gore ga ile msetšwa mathomo la bobedi ba ile kwa Vanderboom ba fitla gana kwa la re ba ile ba khosa yona havoc ka mgo le bileng ka go ka le re havoc le ra gore
ke information e ke bitso go tla go sosia ka bana kwa dealership.
That is the information that I got from my source from the dealership, and then aku bari mhihlu wa usungula na wampiri babi bayalwe ka Mercedes-Benz ba fika ba yenda ama yona madzolonga kumbe ritu leri nga tirhisa ku havoc se ba ku yona havoc ira intswini swi rito rona rero ihlamusele rona kahle se ango hileswi meni nga byeriwaka na mina hi munhu loyi a nga luma ndleve u ve ni byela ku ri va ve va endla ku va na yona havoc.
Case number 2 u ve ba chushisa ka yona firearm para mu office ka mokgwa ba motho ka rona e fela footage na ke itshwere go tswa kwa bona ka a itsheka ka office in chamo ka ke reception.
Okay, le re le msexual we di ba re gala ba chushisa ka sethunya sona se bana le sona. Okay, then according to the information that I got, they say that accused number 2 was threatening them with that firearm, and then the footage that I got, it does not show the officers, only the reception. I get.
Now please tell the court who was he threatening? Who were accused 1 and 2 threatening? With this particular firearm, who did accused number 2 threaten? Are those people state witnesses?
Then rebutse gore mosexual wa mathomo lo wa bobedi o goba mosexual bobedi ibe a tshushetsa mang ka sethunya sona senwe ditlhatsi batho bana ba go a ba tshushetsa ke nana ke ditlhatsi mo molatong mo ke na
Absolutely, that's my worship. God information that you need to some one that move leadership in artists. Aksar show what about Mahala Chushita as I very can move or by the same
I cannot say with certainty that those people are witnesses or not, because I'm not even sure that those people whom he threatened, they are still working there or not, because trying to protect their lives. And then ashamsela mhaka vanhu lava mi ngo a va chaviseta hi xibhamu xexo I vanhu lava mi nga ku I timbhoni na eka nandzu loyiwani a na ntiyiso wa swona sweswo hi mhaka ku vanhu valavo hi ku swilo swa khalenyana mi nga kuma ku na vanhu valavo a va ha tirhi kona kwalaya eka dealership liya va kha va chavela vutomi bya vona.
Now, what was the reason for accused 1 and 2 to cause havoc at that dealership, if you remember?
Then king se si dirileng gore mosexual go ba ena mo gonanelo wa mathomo le wa bobedi ba dire havoc gana mo le dealership ge ba le go ba gana mo le rekiswa mo difatana ge ba neng le a tseba
ke re be bana ka tšhelete ya bona morago le go pole gore bele before case e bulwa.
That was when they were demanding their money back or wanted the refund. You'll remember that that was before the case was opened. And then ako hiloko bona bakabalava mali ya bona andzako mi ta swi hleketa ku ri nandzu a wu nga se pfuriwa.
Is there a likelihood that if accused 2 is released on bail, will endanger the safety of the public or will commit offenses?
Ana go na le kgonagalo ya gore ge le ena mosešwa wa bobedi a ka bulwa ka pele a ka beya maphelo a setšhaba kotsing goba go dira melato e mengwe.
Go bua le my worship.
Yes. Loko swi nga endlakala loko muhehliwa wa vumbirhi o tshuka o chuchiwa hi bail a nga veka vutomi bya vaakatiko enghozini na ku endla milandzu yin'wana.
Please elaborate on that issue.
Ya masama thoko ke nagana ka batho ba batla go kwa leadership ya sala kgona go ya kwa bona a ya go nya ka tšhelete peke ebile a ya solofaya am gore ba phelo a bona a kotseng.
Firstly, I'm thinking about those people who are working at the dealership because he went there to the dealership armed with a firearm. So I do believe that their lives are in danger. And then, Arasama Tom, kitaba ya gore yena ha fel yo akusho sungula egoloko aza hetelela atibona ikwele akushabisiwa kukona timova aya akhomina Josh bam swivula ku vutomi bya vanhu lava ya byi le ngozini.
Where is accused number 2 employed and then, as what?
Musekiswa wa bobedi o bereka kae jwale ka?
Musekiswa wa bobedi o bereka ka Tshwane Tshwane Metropolitan Department officer.
He works at Tshwane as a Tshwane Metro Police officer. Then ako ipolisa ra le Tshwane wele ka Metro Police.
Do you have investigations completed or done as to whether or not accused number 2 owns a personal firearm or he possesses a firearm duty related or a state firearm from that particular municipality?
Then bari le dirile dinyakishisho fitla mafelong re tla go sethunya gore ge yena mosexual wa bobedi o na le sethunya se beng sa gage goba o na le sethunya sona sewe sa mošomong.
O ya le ka nyakisho ka kwa mola ka bona ba mpuditse gore ga ana sethunya se sengwe ka ntle le sa mmereko.
According to my investigations, where he is working, I was told that he doesn't have any other firearm except the duty one. And then kuya hi vulavisisi bya mina le ntirhweni wa yena va ni byele ku u hava xibamu xin'wana handle ka lexi xa ntirho.
Let us go to the assets owned by the accused, that is accused number 2, if you know any.
Then a re ye go dithuto tse leng gore ke tsa gage mosexual o wa bobedi ge baneng la tseba gore motho o na le dithuto tse leng tsa gage not a re ye mo.
We are like open source, which is social media.
Okay. According to open source, which is social media, accused person has got houses. He's got houses. I think it's in Limpopo, Guyana.
Then some of the who sit like a Mercedes-Benz V-Class, you will under finance which are in Alaha.
And then he's also driving a Mercedes-Benz V-Class registered in his name.
What investigations are on to do fixed under his name.
According to my investigations, there is no fixed properties under his name. And then akulo kuri mwehliwa wo sungula wa mumbirhi loko hi ta hi nhundzu leyi a nga na yona hi ta hi swi voni kwele ka valava ka mhaka leyi ya vuhangalasi bya timhaka hi nga yona social media a ku swi komba ku u na tiyindlu a Limpopo ni hleketa ku le Giyani u famba hi movha va nge yona V-class na tona tiyindlu tona teto.
If the accused, that is accused number 2, released on bail, will he destroy or conceal evidence? Is there such a likelihood? Should he be released on bail?
Jwale ge le yena mosexwa wa bobedi ga ka lokolwa ka bail a ka khutiša goba gona go senya botlhatsi ga ka lokolwa ka bail. Go na le kgonagalo ya seo?
Please answer and elaborate.
Le ka no araba la fetša la tlhalosa.
O jwale ba yo shiko felo mo re ba ka setsebi sa molao re la ka lepodisa o ke la go na access to the.
Okay, and that is correct, Your Worship. Here we are talking about an officer of law, and then la re ke setsebi sa molao
O ke la go na le access to the like the resources le chelete.
Where I do believe that he's got a lot of access, resources, money, and then akula hi vulavula hi munhu loyi a tirhelaka tihuvo kumbe a ri nga munhu loyi a tirhelaka nawu loyi a nga kotaka ku fikelela swilo swo tala timali na swona.
Proceed.
So aka dira ntho engwe le nngwe go netefatsa gore investigation a e tswele pele motho.
He can do anything to make sure that these investigations doesn't proceed, and then anga endla swin'wana na swin'wana ku sivela ku ri blavsis byi nga yi mahlweni.
No further questions, Your Worship.
Are you done or you still have anything else to say?
Oh,
Yes.
Oh, but le feditse na go go sana le sengwe se nya go tlatsa ka sona.
Ya ke na ka go le busha court yo gore bobedi jwa bona case number 1 na case number 2 a bona di property tse di go fixed under their name se ra gore o tshaba ka mona re go tlo ba bonolo for bona.
Okay, what I also want to elaborate on accused number 1 and 2 is that they do not have fixed properties which are registered under their names, so it will be easy for them to run away from out of this country. Yeah, and then a hlamusela timhaka ta ku vumbirhi lebyi bya vona a vo va na nhundzu leyo ka yi nga tlakuleki nga le mavitweni a vona leyi nhundzu ya kona leswo swi nga endlaku ku vona loko va lava ku huma handle ka tiko lera hina ra South Africa va nga ha no famba. Ku sanalisisi n'we?
Awa.
That's all.
Defense, are you going to start with your cross-examination now, or will first adjourn for lunch and then you can then pursue your cross-examination thereafter?
I think in the interest of time, we'll start right after lunch because it's not going to serve any purpose. It will just be 5 minutes and then
State seem that we are somewhere 10 to 1. What time do you think we should return, both to the state and the defense?
I propose 10 to 2, Your Worship.
Is it okay?
Your Worship, I propose, because normally we would resume at 1:45, and we are for the 10 minutes prior to 1:45.
So what are you saying? We resume at 10 to 2 or what?
At 22, because there's a 10 minutes advantage.
Let's make it 10 to 2 so that people can eat properly. Somewhere others are still going to cook here. We will resume at 10 to 2. Go ahead.
Thank you.
Witness Kutiso Tobejane, you are warned that you are still under oath. You may be seated. Defense, you may now pursue your cross-examination if any.
Court please, yes, I am instructed to proceed with cross-examination. Mr. Tibane, there are certain questions that I would like to ask you. This emanates from your evidence with respect to the testimony that was led from Friday until today.
Diputiso tse ke di tswa mo botlhatsing bo leng gore le go file ke lena botlhatsi ba bona bo leng gore le thomile go bo fa go tloga ka la botlhano fitlhelela le kgono.
Can you clarify?
Yes.
Can you clarify this point, Mr. Tobejane? When did you obtain the warrant for the arrest of accused number 1 and accused number 2?
Then, Mr. Tobejane, lengwalo la ba babedi ba swariwe msection wa mathomo lo bobedi le le kgweditse neng?
Okay, shokati mara ke nagana gore ke July.
I'm not sure about the date, but I think it was in July.
Worship, with permission of court, I have been provided by the state with a copy of the warrant when we requested same, so as to refresh Mr. Tobejane's memory. I humbly request to hand him up this copy for that purpose.
Se ako bako ndaku mbutsen ka swivutiso loko swi ta ka vumbhoni lebyi mina mi nga byi nyika kusuka hi wa vutlhanu ku fikisela namuntlha se papila lero va lava mbirhi va khomiwa miri ku mirini ako a na ha swi hleketi kahle bara ni hleketa nga ku ri July se ivi gqwetha ako ni na papila leri ni nga na rona leri ni nga nyikiwa ro komba ku lava mbirhi va fanele va khomiwa ni nga ku nyika rona ku u ta kota ku tsundzuxa mihleketo ya wena. Do
you recognize the document before you, sir?
Yes.
And what is it?
King.
Warrant J50 page for accused number 1 and accused number 2.
Nonyane is a 2J50 for accused number 1 and accused number 2. And
my affidavit.
And also my affidavit. And then ki mangwalo ama ima maphepha mambirhi o hlamusela ku ri vahihluwa lava va fanele va khomiwa ra muhihluwa wo sungula na ra muhihluwa wumbirhi ku ri na yona affidavit ya mina.
And just so that you can be certain, what date appears to be the date in which you applied for the warrant as well as the date in which it was authorized?
Bari tšatšile lena le dirileng kgopelo ya lengwalo lona le bola ba babedi ba swariwe le tšatši le filweng lengwalo lona leki goba tšatši le dumeletsweng gore ka nnete ba babedi ba tshwanetse gore ba tshware ke neng le neng
kope le dirile ka di-30 tša July ebile authorized ke 30 tša July.
Application was made on the 30th of July and it was also authorized on the 30th of July. Then xikombelo xi endliwa hi ti 30 ta July, xi mukeriwa hi ti 30 ta July, kumbe xi pfumeleriwa hi ti 30 ta July.
Will I be correct to say that on the 30th of July, you had the full particulars of accused number 1 and accused number 2?
Jwale ke tla ba ke bolela nnete ke re ka di 30 tša July e be e le na le botlhatsi ka botlalo ge re tla go ditaba tša yena Mosexual wa mathomo wa bobedi. That is correct. In ntiyiso a ni ri na vuxokoxoko hinkwabyo loko swi ta ka mhehliwa wo sungula na wa vumbirhi.
Will I be correct that you testify that you arrested accused number 1 on the 17th and accused number 2 on the 14th of August?
Ke tla ba ke bolela nnete gore Mosexual wa mathomo le motshwere ka di 17 and then o wa bobedi le motshwere ka di 14 tša August. That is correct. In ntiyiso mhehliwa wo sungula ni nkhomi hi ti 17 lo wa vumbirhi ni nkhoma hi ti 14 ta August.
Is there any reason why it took you 14 days to be able to execute this warrant of arrest?
Is there any?
Okay. With respect to accused number 2, is there any reason why it took you 14 days for you to execute the warrant that the court had already authorized on the 30th of July, notwithstanding the fact that you had the full details of accused number 2?
Ba re jole go na le baka le le dirileng gore lena le yemele mati le dule sebaka matšatši a 14 a ba feta le sešole motshware mole le na le dilo ka moka goba botsebi ka moka goba le tseba dintlha ka moka ka yena go tša yena Mosexual wa bobedi mo le leng gore kudu ka baka la gore le ngwabelela le kgopetše ka di 30 tša July ke moka ba fetša ba lefa lona ka di 30 tša July. Jale go na le lebaka le le dirileng gore le tšee sebaka ka mokgwa. Yes, we do have reasons to that effect.
What are those reasons, sir?
Ke ya mafe mabaka a gona.
Le ya go dira a re go bereka ka ntle gore ya go dira arrest. We plan this team apply and resources to arrest.
Your Worship, I'm not arising with an intent to disturb, but I still hear the mixture of languages. I'm not sure whether the witness for God and maybe can be reminded. Thank you, Your Worship.
Mr. Tobejane, I thought you maybe should listen to yourself. You either speak Spanish or English. And avoid mixing, going and taking this as if it's a vernacular sort of tongue. So use one language at a time. Tobejane, do you understand?
Ntate Tobejane, ba re ka mokgono le re boletseng ka gona. A re mo ema mo polelong e tee ya ke re se ka nna re tsentša mo le mo le ya kušitša
Noted.
o
Maybe understanding English but communicating in Spain.
ke a kušiša gore le ka no ba le kušiša Sekgowa fela ka gore ba re lena tswalampe le bolela Sepedi
With a raised voice.
le bolela godimo a ke re correct.
Thank you, defense. Mamlaka, you can proceed.
Escort, please. You were still explaining the rationale behind the 14-day gap from the obtaining of the J50 to the execution thereof.
Be le sa tlhalosa gore go tlile jwang gore go be le matšatši ana wa matelele le a tšereng a go se mosware ka morago ga matšatši a 14 le sa tlhalosa gore tshepedišo ya lena tsamaya jwang.
Tshepišo ya rena ke re ya go berekela kwa ntle gore ya go dira re go tshwara motho ra beakanya e se team.
Okay, then if we are intending or we are going to arrest a person outside, we do the preparations. Then we also request things that we are going to use when we are about to effect the arrest. Don't just wake up in the morning and say we are going to arrest. They deposed us actually at that certain place and then task us accordingly. And then ako loko hi fanele hi ya ku khomeni ka munhu loyi a nga wa le handle kuna leswi swi fambisiwaka kumbe kuna leswi endliwaka xo sungula ha ti lunghisela xa vumbirhi hi tlhe hi ti lunghisela na swilo leswi hi nga ta fanele ku swi tirhisa loko hi ya khoma munhu yaloyo a ho pfuka nampundzu hi ku hi ya ku khomeni ka munhu xin'wana xa kona ho yisiwa kumbe ku byeriwa ku ri fambani ka ndhawu yo karhi and then xin'wana xa kona va tlhela va hi byela ku ri ni ya endla yini.
Is that the reason why you took 14 days to arrest?
My worship or is application, application very regular kinds of progress around. Is application. Is application. Is application ya by check. That's my cabo.
And the other thing is that I made an application to go so that I can go and work outside with my other colleagues. It was rejected due to their own reasons. And if we are going to work outside the province, we don't just go, we make an application. And then, shaku ifane shaku ifane ya tirhela ahandle na vatirha kuloni kambe xikombelo xexi va xi ala mi swi tivi ku va xi ale leri ngo yini swi tiviwa hi vona loko hi tirhela handle a wo tshuka no ya handle ku na xikombelo lexi endliwaka.
On the same breath, let's say we accept indeed that you had these internal challenges to get to accused number 2, who's at this moment in time residing outside the province of Limpopo. What then have you done with respect to accused number 1 up until the 14th of August? And I say this on the basis that you testify that you've got some affidavits from the LPC regarding accused number 1, who obviously have particulars and details of an office. What have you done to secure accused number 1, who was within this province, within what I would say a stone throw away from you in the same town, as far as from the 30th until the 14th of August?
Then, okay, ye mo sexual bobedi ra e kwa ra ipishisha ya gore le tlhakane le bothata mo le mole re tla go tabatsa dithulaganyo tsa mo officing ya lena gore le kgone mo tshwara matsatsi a 14 a ba a feta akere jwale gona le dirile eng ka sexual wa bobedi o le gore o dula gana mo province ya bolena gana mo Limpopo mo le gore le tlhalositse gore ibile ba le shetse le mo reportilana kwa LPC. So yena o le gore o do ba moaishane ha le goba o do ba gaufi le lena yena ka re lebeletse taba tsa gore le re motswere ka 14 tsa August.
My worship sinke kare ke report accused number 1 LPC get agreement le accused number 1 moka ka hona go report LPC sinke kare ke mo report LPC ke le ka family ya mathabata mo report LPC, not investigative officer.
I never said that I'm the one who reported her at LPC. I only said the Matabate family, they're the ones who reported her there at LPC.
I also never asked you that. Maybe let me rephrase. Perhaps it's an issue of interpretation. My question is strictly as follows. What have you done to secure the arrest of applicant number 1 from the 30th until the 14th, in view of the fact that you testify that you have an affidavit from officials of the LPC, and on that basis you'll obviously have particulars of accused number 1, and accused number 1 practicing here in Polokwane? Not that you reported her. You didn't have capacity to do so.
You should not be that long because I might not be able to capture each and everything that you're saying.
It's fine. No?
But I got it, it's fine. Then, Arlene, avec ce qui voulait le so, fait la kiri. C'est ce que voulait dire. Elle écrit les cas de date, cas de date hacker. But le dirile mo fitela ka di 14. Le na sengi ke re le na le mo reporting LPC. Ke rile ba LPC ba na le affidavit. And re tlhaka ntse le taba tsa hore ba LPC ba na le botlhatse go ba na le dilo tse dintsi tse go ba di tseba ka yena le dirile eng re lebeletse taba ya go motho ba re o tswa gana mo Polokwane
ba go shi go tswa Polokwane ga se gore ke tsoga foro ka ya go motshwara ya applique ya khopelo ya gore ga go tshwara motho re go probata details ka mo ka tsa case ba probata di resources
banyana the issue of her staying in Polokwane, it doesn't mean that I'll just wake up in the morning, go and arrest her. We are required to make some application. And then we make applications when it comes to the resources that we are going to use when we are about to effect arrest. ABC ahlamusela timhaka ta ku u endli yini kusuka hi ti 30 ku fikisela hi ti 14 ta July ta Mkhoma loyi wa la Polokwane hi ku u hlamuseri ku ri ba LPC kuna affidavit leyi humaka ka LPC and vanhu lava va le LPC munhu lo va n'wi and u tshama kwala Polokwane ivi se loko a ti hlamulela a ku tshama ka yena Polokwane a swi vuli ku ndo pfuka na mpondo ni fika ni Mkhoma ku na swilo leswi swi endliwaka ku na swikombelo leswi endliwaka ku ri hi tlhe kombela na swilo leswi hi fanele hi swi tirhisaka loko hi ya ku khomeni ka munhu yaleyo munhu wona waleyo.
The applicant testified that in as much as she became aware that you are seeking to execute an arrest warrant on her on the 14th, she handed herself up to you on the 17th. What is your comment to that?
Baku yena mohishwa uri loko sentale mo na pile yena mo gone lo a re tlole mo gore gape ke anya ke ka 14 ke moka a kitlisha ka 17 wena o reng ka tlatsa
ke ne tu tlira 17.
That is correct. She came on the 17th.
Now,
so we are at the 17th.
You testified that if applicant number 1 was to be granted bail, she will evade the trial. How do you correlate the two between the fact that on the 14th she became aware that you need her, in as much as you did not arrest her on the 14th. Some 2 days later, on her own volition, she brought herself to you for purposes of execution of the warrant. How do you correlate the preposition that you gave to court that she will evade vis-a-vis the fact that she eventually brought herself to law enforcement?
Napile moemedi wa msekishwari jwale tete pedi o di nyalantsha jwang ka gobane motho o kwile re wanyeke ya ka di 14 ka morago ga matsatsi a mabedi a kitlisha court wena o re motho ha ka lokolwa ka bail o to thabela molato jwale ngo re tlhalosetse mo tabeng tse pedi ka gore motho shu wa kisha court he ba re wanyeke wena wa rawa motho ha ka lokolwa ka bail to tshaba.
My worship, warrant of arrest take sur J50. I had put at the police station here. I came at tomorrow. Want to hope it's at us out. What was 14? August 2024. What official? Kitum Soraka, Kamantia, and open tomorrow.
Your worship, the warrant of arrest J50 that I'm in possession of, it doesn't say that the person must just brought him or herself to the police station. It says that I should go and arrest that person wherever he or she is. From the 14th of August, I was requesting that she tells me her whereabouts, and she was not. And then, loko ku ri papila rona ri riya ra ku munhu a khomiwa a ri zi ri hlamusela ku ri munhu fane a ti tisa police station ri ri swi veka kahle ku ri mina ni fane ni n'wi khoma kusuka hi ti 14 ni kha ni n'wi vutisa ku ri u le kwihi ku ni ta ya ni ya n'wi khoma a kha ni jikajika.
Mr. Tovajani, when did you get, or when were you placed in possession of the passport of applicant number 1?
Then passport ya mo section mathomo ba le file yona ni
ke nagana gore ke ka la bone ka di 20 August 2024
ka di 20 August 2024. I believe it was on Thursday 20th of August 2020.
sorry 2026
2026.
Okay.
And then September akuri wa mune the 20th August 2026.
Will I be correct to say that from the 14th to the 17th, at the time where she handed herself over to your office, she was in possession of a passport?
Ke tla ba ke bolela nnete gore go tloga ka di 14 go fitlha ka di 17 a ke tlisha officing tsa lena ibe ana le yona passport eo.
aseneti.
That is not correct. Akusweswo a hintiyiso swa ku kusuka hi ti 14 ku fikisela hi ti 17 a ri na passport loko a hetelela a ti tisa ti officing ta vun'wini ta hina.
Mr. Tovajani, just testify that you got the passport on the 20th of August. So, who had the passport at that time?
Le fetsa go bolela gore o le file passport ka di 20 tsa August. Ka nako e ka moka yona passport e bena le
ka di 20 mo bekeng ke ile ka kwa police station o fonisitse a case number 1 ke na o shitse phone ya colleague ka o phone ra ba tswe ba go ba tlise passport e tlile a ke sno wa o verify address kwa
accused number 1 called, he used my colleague's cell phone to contact her parents that they should bring her passport at the offices.
Then Musara ke mmereko ba mpitsa kwa isebetsa police station ba re ke ke passport a case number 1.
Then during the day while I was on duty, I was called that I should come to the cells to collect the passport of accused number 1. And then ako moetlo wa go sungula o bi a founela batswari ba yena gore ba ta kota go tana passport la at office ta yena o bi a tirisa phone ya Nonyane loyi tira kuna yena gore kumbe ntira clothes se ina sikani ni bini phone riwa ba butana leti seleni o ta teka passport ya moetlo wa go sungula.
Mr. Tovajani, the question is, who exercised control over the passport from the 14th until the 17th, according to your understanding? Since you didn't have it in your possession, who had control over that passport?
Usually, Lena Ekauri, Puchishakur, she a haka, Hotoka 14 of Fitlaka 17. Kimma, ebe Ahona of Fitla passport to Carolina Bellis Nail. Maybe I don't understand the question.
I put it to you, sir, for you to understand that as far as the 14th and the 17th is concerned, applicant number 1 exercised control over her passport, and it was not in the position of the state at that time.
Then Naki Alibuta or Lohono Kushish Musexua Matom, ebe passport of Limoyena, Gadi 14, like 17. Gauri Besna, Bamusho, Hoba, Bachuchis, Hobalina Police. Barjoli, Billy Moyenne, Kiana, a little banal mat out of Hona Oshisha passport in Probably Moyenne.
Power kids, or reveal more when our is more, not to kiss our worry. Colleague, I fully food, giving a bona, a funeral, but so you are about passport, can it by to passport in Moody City. That
one, I know nothing about that, but what I know is that she used my colleague's phone to contact his parents so that she must bring the passport. Indeed, the passport was brought at the police station. I went and fetched it at the SARS. Then akushesho mina ngishitivi kambe lexi xi tivaka i ku yena u ya kombela foni ya munhu loyi tirhaka na yena munhu ivi a fonela vatswari va yena ku ri ti-sun passport himpela ni vi ni yi ta ni ya kwele tiseleni ni ya teka passport.
On the instructions of applicant number 1, it's a fact that she had control over that passport, and therefore the question is, your preposition that she will evade her trial if granted bail, we submit that it's not supported by the objective evidence before us, being one, as soon as you sought her arrest from the 14th, while she had the passport which enabled her to travel outside the Republic, she remained here in the Republic.
Se anapila arawa chego je wana ulibulela nja gore muthu akathabela molato na ra go tswa je wa se dinnete ka go baneng re ro tlhaositse re tsa go lego tsala tsena tsa passport ka gore isale a tseba gore yena o nya ka go tshwariwa go ba lenya go motshwara ka di 14 ene ba ntjana le yona passport yona eo ba re le botso gore be le mo matlong a gae e ka be le motho wa go tha ba ta ba jile fast
nkabe ke se motho bana ka tshebela molao nkabe a jimetse gore ke motshwara ka di 14 tsona tse.
If she was a person who was not going to evade trial, she would have allowed me to arrest her on the 14th. Baku nina njwela kuri munhu loyi passport ya maboko na yena kuri yana ntsena loyi angana khomi passport ya le ya yena ene na kula khomiwa u swi tivi hi 14 loko a tiyimiserile ku la ku tsutsuma a ta va chavi khale kumbe kona ku baleka se ivi yena a ku loko ku ri a nga tiyimiselanga ku baleka a ta va pfumeli ku ni khoma hi 14 tona teto.
Mr. Tobajane, it's a fact that she handed herself over to you at a period where she exercised full control of that passport. It's not a question of what could have happened on the 14th. I'm raising a specific issue with you regarding the likelihood that she will evade. That despite being in possession of travel documents, she still came to you.
Ba re jwale a sita ba tsa gore go tlo ba go tshwantsho go di ya eng ka di 14 go ba eng se nna re se bolelang go gore re bolela ka kgonagalo yeo ya gore lena le o tlo tshaba gape ka nako eno engwe ibe a sana le yona passport eo a e swere mo go yena. Karabo
No, I keep going to petition my lord.
Don't understand the question.
It's okay. Applicant number 1 testified that she does not have any assets outside the Republic. And again, following up on the 14th and the 17th, the position of the passport, she has testified before this court that she has got no assets outside the Republic. And we submit, we just wish for your comment on that aspect of the fact that she had the travel document, she didn't travel, and she has nothing outside the Republic. What's your comment to that?
Mseshwa mathomo tlhalositse gore nna ke ne thutu e beng maineng a ka ntle mo nageng tse dingwe ene se sengwe gape le taba ya gore re lebeletse gore motho le passport gale a e swere mo seatleng lena le reng ka taba tseo gore nna ka kwa ntle ga naga ya South Africa ga ke ne selo gape ba le passport o na le yona le reng ka taba eo.
O henta in passport ga gagwe a se gore a se flatile ka gore passport o ke ntho ka dira gore ka 30 minutes e o e nyaka.
For her to hand over her passport doesn't mean that she's not a flight risk, because you can do a passport within 30 minutes if you want. And then ku timhaka ta ku yena u nyikile passport a swi vuli nchumu sweswo a swi vuli ku yena a hi munhu loyi a nge le nghozini a nga chavela ku nandzu lowani hi mhaka ku loko u lava passport swi teka na nchumu 30 minutes u nga yi kumi
ne go chavela mola wa se gore ba re ko o kile o itwa ka nageng ya Africa Borwa.
And then to evade trial doesn't mean that it doesn't mean that one should just leave the Republic of South Africa.
That aspect, with respect, Mr. Tovejan, will deal with it in argument, particularly because the evidence that is before court today, as far as that aspect is concerned, is that with all those possibilities, as you are saying, that she could have run to some other parts of SA, she still came to you.
But here where na re tlo bolela hentse re di ya dinyanyishana mo pela khoro ka hore godimo ga ditaba tse ka moka tsona le di buletseng tsa go yena motho a ona le kgonagalo ya a ka tshaba fela a senki ka a tshabe a ntse a sa tshwere a na le passport and then a go swa go munhu a ka tshabela nandzu a ti mhaka to yena a tsutsuma a huma a handle ka tiko ra hina nambi ebi swin'wana a hlamusela timhaka ta lebi se gqwetha ri ku sweswo hi ta swi vulavula loko se hina hi hlamusela huvo ku nandzu loyiwani wa xikombelo xa beli hi wu vona njhani hi mhaka ku hinkwaswo leswi nga swi hlamusela la mahlweni ka huvo swa ku ta chava na yini a nga chavangi ku ve passport u na yona mavokweni na yena.
Mr. Tovejan, you in your examination in chief dealt with an aspect to do with a Matabata family that according to your testimony appears to be clients of accused number 1, being applicant number 1 for purpose of today. Do you perhaps know if that family remains clients of accused number 1 as of today in terms of a professional services?
But then lena ge le fa botlhatsana mo le boletse ka lapa la ga Mathabate jwale ka batho ba le gore ke batho ba homosexual wa mathomo goba re ka re ke batho ba homosexual mathomo ba mo hirileng gore a ba thushe jwale ba re potšišo kore le a tseba na a hele baneng batho ba Mathabata e sa le batho ba le gore ba hirile ba sa berekisana le ena homosexual wa mathomo na
awa a betsebe go na go eme jwa wa di jwale ke tsaba gore ke ba le mo processing ya go mo tlosha jwale ka berekisana mo
mang wa tlosha ya go mo tlosha
na ba Mathabata go processing ya go remove accused number 1.
I don't know what is the current position right now, Your Worship, but what I know, or the information that I have, is that the Mathabate family, they were in a process of firing accused number 1.
Based on that, are you prepared to accept that if at this point in time they remain her clients, she then would have been entitled at the time that you allege that she contacted them to contact them because they were her clients, and that an attorney and client relationship existed at that time?
But jwale ka baka la taba tsona tseo tsa gore tshena le fetsa go tlhatsana mo le a tseba gore a ka no ba a ile a homosexual mathomo a ile a boleshana le bona ka go baneng ba tshwanetse ka go baneng ka nako ene yobe e be e sa le batho ba leng gore yena o shuma mmogo le bona. I'm not sure about that. And then baku a hlamusela timhaka ta ko a ni swi tivi ku ri na ka nkarhi wa sweswi munhu loyi wa tirha na vanhu va ka Mathabate kambe leswi ni nga byeriwa hi vanhu va ka Mathabate va te a va ha endla xikombelo xa ku va fane va n'wi susa a nga ha vi yena a va pfunaka eka tifayili ta vona ivi a ku a henhleni ka leswi wena u nga swi vulavula u nga yi kaneta mhaka ya ku munhu loyi muhehliwa wo sungula a yisa mahlweni na ku vulavurisana na va ka Mathabate hi ku hi nkarhi wona wa luya loko a vulavula na vona a ka ha ri vanhu lava a tirhisanaka na vona.
The point I'm trying to make to you is on an assumption basis, because you yourself cannot give an accurate answer, that in the event that it is found that at the time that you allege that she contacted them, and by the way, which she denies, there would have been nothing wrong with that, because they would have still remained headlines, and an attorney and client relationship would have existed at that time that authorized her to be able to contact headlines in a professional capacity.
Lena oba wena o bolela ka bona bo o sne phosho e beng gona ka gore motho o gale a berekana le ba mathabate kudu re lebeletse taba ya er ibile yewe ya go boletse le bona wa e gana mara re do fishetse re go bolela gore kana go yela e be go sne bothata ba ra ka bolela le bona ka gore batho ba e be batho ba gage ba thushana
nna ke nagana gore e be le bothata ka gore o ba fonetse gantši
According to me, I think that was a problem because she was calling them constantly and then until they blocked her and they were busy saying she must stop calling them. And then kuya mina ni bona ku ri na xihoxo hi mhaka ku ava fonela siku rin'wana ava fonela minkarhi yo tala loko ava fonela minkarhi yo tala va n'wi byela va ku nga hi foneli ivi va za va hetelela va n'wi bloka.
The point I'm making to you, sir, which is as clear as it can get, is this: that if at the time that you allege she called them, a mandate had not been officially terminated in terms of the processes of the law, there would have been nothing wrong in law for her to contact headlines.
Usually, none tell more than you Kaisha more. Kiabori, Hey Banning Hale Abafune, Bastrom Kubisi Musho. But what's not posho ye by dear? Kabori Batuba, Pesale, Batuba Are. Nan taking away Kaisha Mu or Bakinyo Buncha Butzega. Gord, Banning Sedul had Anja Jola Pilava Funelaga. A bay was never tata. Banning Bobasi Chobam Kubi, we are come loud. Yakushisha.
No comment,
no comment.
It's okay. You testify that the genesis of this matter comes from a dealership in Pretoria in Vanderboom. Am I correct?
Vanderboom, Pretoria. That is not correct. I never said, or maybe I missed the genesis meaning.
I'm trying to say that you testified that at the commencement of the alleged offense was at the place there in Vanderboom, because you testified that accused 1 and 2 approached a particular dealership to purchase a motor vehicle.
Lirile oba buya ka Tibana lirile molatho di agetse kwa Vanderboom ka ge mosešwa mathomo la obedi ba le ka go reka sefatana
my worship asinye ka re matuzi le tse Vanderboom ke le molatho le tse go kwa ka tswele le go tsara le Polokwane le go.
I never said this matter commenced at in Polokwane. I mean in Vanderboom. I said here in Polokwane. That is why we are finding ourselves sitting here in Polokwane.
Sir, those issues that you are now dealing with, it's not what I'm asking you, but let me rephrase. You testified, in fact, it also exists in your own warrant that you have in your affidavit, that accused number 1 and 2 approached a dealership in Vanderboom in Pretoria.
Actually, okay, iriki katsela yeki lena le buletse gore mosešwa mathomo la obedi ba ile ba ya go yona dealership kwa Pretoria le J50 ya lena e tlhalosa sona se. That one is correct. Ebe akomina anzangi nikumlandu le sulile a Pitori Vanderboom. And lesson nga subulisa son secretary okay one kusubeka endlela leyo ngatasitwisisa wena uri bumbiri bya vanhu kumbe lavambirhi babi va tlakuka va ya kwale ka dealership a Vanderboom a ku sweswi ntiyiso.
And that the draft charge sheet as well as your affidavit on the warrant supports the position that a complainant is one person that is appointed or that works for Mercedes-Benz. Am I correct?
Bakuna barena pile li tlakala la molato li tlhalosa ga botse gore mollo ke motho le gore o shumela kwa Mercedes-Benz Vanderboom. Correct. Itiso gore ngwani wa bapoti ba nantu o tirela le a Vanderboom.
That's what I was trying to say. The genesis of the matter is in Vanderboom.
Ke se ke le ka mo se bolela gore ga botse botse ditaba di thomile hana kwa Vanderboom.
My worship with it. I fara ka basatsi jwa ka mokho. That is why to tshara Polokwane hole is because what the fruit referred to no Polokwane.
Your worship, as I've already testified that they have defrauded the files which are here in Polokwane. That is why we are finding ourselves here in Polokwane. Ni vini swihlamsela ku ri vanhu lava wani va endle vukungundzwani eka milandzu kumbe eka tifayili leti nga la a Polokwane hi swona swi endlaka ku hi tikuma hi ri kwala namuntlha.
In as much as you are still busy with your investigation and we'll deal with that at the ultimate trial, will I be correct to say that the complainant remains that individual from Mercedes-Benz for purpose of the time that...
Switch off your
Sorry about that, Your Worship. I got distracted. There seems to be a phone that is ringing in the front. I humbly request the court to remind our colleagues because it's quite distractive.
Please ensure that all your phones are off. Everyone else.
Now, if we are in agreement that a complainant is working for Mercedes-Benz, would we then be also in agreement if we put it to you that neither of the families, the alleged clients of accused number one, are complainants at this moment in time, as far as your affidavit is concerned and the facts that are before court, insofar as what the state has led? That the ultimate complainant is at Mercedes-Benz due to the alleged commission of financial crimes.
Hebaning readumelana gore molli mo molato moki ke mmereki wa kwa Mercedes-Benz aga a gona loti o lo more mosekisha ebe a ba thusha ka di file o le more re lebeletse botlhatsa wa batho ba tsene lebeletse ka ke molli
o jwala ma yoshi.
That is correct. And then aku inti sokuri loko hina uti bumbuni ka kangwa sweswi a nge vuli loko hina uti bumbuni lebyi wa bya zwakwe le Mercedes-Benz because munhu loyi anga yena mukoti wa nandzu kwale ka Mercedes-Benz hi nge vuli ku na munhu loyi anga mukoti wa minandzu loko hina uti lava wani a tirhana ku na tifayili ta vona akuko hava na un'we ka lava a tirhaka na tifayili ta vona loyi hi nga ta ku I mukoti wa nandzu.
With that understanding, I put it to you that any contacts whatsoever that you may allege were made by either accused one or accused number two to anybody out there will not utter anything because the complainant in this case is a person in his representative capacity appointed by Mercedes-Benz.
Arjole na ke alibutsa gore politician o ifika pa ifi yem se shwa mathomo ba o bidi aka idirang le motho mo lo mo yewe e ka se be le seabe molatong ona o ke ka gobane ge le molle ke molle o leng gore o ikemi ka bo yena wa go berekela Mercedes Benz.
Because it is not wise to drive this line of questioning for argument. Because in a criminal case, the complainant is the state. It's not wise to reside that far.
Your Worship, I submit not, and the basis for that is this. My line of questioning is going to a particular point.
Thank you. Let you not disclose your point.
Yes.
Abo dzela yena gqitha kuri awuboni swiyantswa sweswo hi ta swivutisa u ta swi hlamusela endzhaku ke avo hayi ku na xivangelo lexi ni endlaku ku mina ni khumba kwalano se va ku hayi u nga hlamuseli u ya mahlweni ngoni yisa mahlweni na swivutiso swa wena.
I was seeking a comment from this.
No comment, my worship.
Akwana hlamulo loko swi ta kwalano.
You also testified that, and perhaps I wish to just clarify that the questions may interchange between 1 and 2 based on what you said, so there shouldn't be any confusion. You testified that because accused number 2 is an officer of the law in the form of a traffic officer there at the city of Tshwane, he will be able to potentially interfere with investigation or tamper with evidence. Am I correct?
Le file botlhatsi la re ge le yena msekisho wa bobedi ka gore ke moshumedi wa mmusho wa molao ke motho o leng gore ha ka lokolwa a ka shitisha goba gona go shitisha dinyakišišo ke nnete sewe. Yes.
Perhaps we'll just seek clarification from you. If we accept that the complainant sits at Mercedes-Benz, how do you suggest that accused number 2 will be able to tamper with electronic evidence that has been stored at the custody of a big company such as Mercedes-Benz by merely just being a traffic officer?
Then ba re nko le re tlhalosetseng taba yake ga botse re kgone go kwisisa jwale yena msekisho wa bobedi o tshwenyana jwang le taba tse tsa dinyakišišo goba gona go šitiša gore o diwe dinyakišišo ka mo leng gore molle a kere ke wa Mercedes-Benz ke company e kgolo bohlatsi ba gona bo mo re ka no re tsona di-computer goba eng jwale yena ka o duba lephodisa la kwa metro yena o senya jwang bohlatsi bona bo goba go šitiša go dira gore dinyakišišo di tswele pele.
Go šitiša dinyakišišo go tswela pele ga se fela go wala access go electronic evidence go ya kwa Mercedes-Benz ka go yena go šitiša dinyakišišo.
For him to tamper with the evidence is not just that lireless as in
go šitiša dinyakišišo ga so go ba access to electronic evidence fela.
Oh, it's not for him to have an access to the electronic evidence only by the fact of him going there to the Mercedes-Benz or Mercedes-Benz. La we are Mercedes-Benz in
we are Mercedes-Benz how go tja bona batho ba go ga mo thusha kwa tjiwa a go tja go tsona go šitiša dinyakišišo.
For him to go to Mercedes-Benz, told them whatever that he wanted, it is to interfere with the investigations. And then ahlamsela makako ute yena moisi wa umbiri ipurisa raka metro se loko a ri phorisa raka metro uta endla ku ri vumbhoni vunga ku ri va nga vulavisisi byi nga yi mahlweni hi ndlela yihi hi ku loko hi langutini ute mumpoti wa nandzu eka nandzu loyiwani i munhu wo tirha eka Mercedes-Benz se na vumbhoni bya kona va byi tumbetile ka swilo leswi swa xilungu nga swi vitana ku xana to ti computer kumbe yini se u ta swi fikelela njhani a ri phorisa ntsena se a ngo ku endla ku ri ku nga vi na vulavisisi byi nga yi mahlweni a hi ntsena ku ri yena a fikelela vumbhoni lebyi nga le ka tikhompyuta kumbe ka yini na ku ya kwele ka ma-citizens ntsena a fika va byela swilo swa va byela swona a swilo sweswo hi ku endla ku ri vulavisisi ku sivela vulavisisi ku ri byi nga yi mahlweni.
Do you have any evidence to suggest that besides the date in which allegedly a refund was sought, either of the applicants have returned to Mercedes-Benz, the very same specific dealership?
Then dina le botlhatsi ba go tlhatsela gore batho ba babedi ba ile ba buella kwa ana kwa dealershiping yona ile Mercedes-Benz ka ntle ga tšatši le la ba re ba ya ba nyaka tšhelete ya bona morago go na le botlhatsi bo mongwe ba go tlhalosa gore ba ile ba buya gape. No, I don't have such evidence. Anamboni zo hlamusela gore lava mbirhi handle ka siku leri yavengi va yini va vi va tlhelela futhi.
Your Worship, I beg the court's indulgence to approach accused number 2.
Yes.
Thank you, Your Worship. Is it correct that at the time that they went to, or allegedly went to seek the refund, they were not under any investigations at that time by law enforcement?
Ke nnete na gore nako e la ba ya ba re ba nyaka tšhelete ya bona morago be go sene dinyakišišo tše e leng gore di a diwa kgatlhanong le bona ke ba molao. That is correct. I ntiyiso ku ri loko va ya leni va ku va lava mali ya vona ndzhaku a ku nga si za ku va na vulavisisi lebyi a byi endliwa a henhleni ka vona hi va nawu.
Both accused 1 and 2 testified that they have been aware of this matter or their disputes with Mercedes-Benz as far back as 2024, and up until to this day they did not interfere with that process at Mercedes-Benz. In fact, they've gone on to attach an annexure to their bail affidavit with permission of this court. Your Worship, I would like to question the witness on the contents of this particular letter. However, it has been attached to the exhibit A and B for both parties. Will the court allow me to hand this? I've got a copy on me, unless if the position is that I must show them what is on the affidavit.
State any objection?
No objection, Your Worship.
I think you can pursue.
Let's copy this. May I to assist her too?
Babu,
You check if the document is the same.
Oh, that's okay.
I did check it, Your Worship. I can just...
I've been courteous enough, Your Worship, to show them what
did.
we intended to lead evidence on. Time has.
Thanks, Your Worship. I'm satisfied.
Thank you. Defense, we can proceed.
na pile before Alpha Pampiri ba sa bolela ka taba ya gore ba babedi bentse ba tseba gore ba nyakišišiwa go tloga ka 2024 fela a sanke ba tsenelela ka gare ga dinyakišišo goba go thibela gore dinyakišišo tše di tšwele pele. So go na le pampiri nngwe le leng gore re ile ra ifa kgoro gore tlaletse botlhatse go bontšha gore go bontšha gore ka nnete-nnete bentse re tseba gore ra nyakišišiwa go tloga ka 2024. So pampiri ya gone ke ye le mo matlhong a lena.
Were you familiar with the contents of that letter? Have you seen that letter before?
Pampiri e ba re nkile la e bona pele.
I see the people before.
No, and then bakulava mbirhi va ri hina a hi swi tiva kusuka khale ku halavisisiwa kusuka hi 2024 a ku lava mbirhi va kha va swi tiva ku ri va lavisisiwa hi 2024 a va zangi va endla swilo leswi swi sivelaka ku vulavisisi byi ya mahlweni se a ku ni ta ku nyika phepha rin'wanyana ro komba timhaka teto se phepha leri u zu ri vona na ka ku nga va ku va wena a ku a ndzi tshama ni ri vona.
Just beg the court's indulgence. I would like to open a copy of the said letter. Mr. Tobejane, I would like to refer you specifically to paragraph 3 of the said letter. Are you there?
Regana mo paragraph number 3. Yes, yes.
The applicants have testified that as a result of what is on paragraph 3, they became aware that a certain Colonel Makua at the time was involved in this matter from SAPS, whose details appear there on the email. That's what they testified to in their bail affidavit.
Very usually, basekishwa ba file mtlhatsi ba hore rina re ile ra le mo shwa go ba go tsebishwa gore go na le dinyakishisho tse le gore di a diwa godimo ga dinyakishisho tsona tsewe motho a dirang dinyakishisho go ba o mongwe le gore o gare ga dinyakishisho tsona tsewe ke yona colonel yes Makua ba re gona gana mo pampiring eke.
Is the colonel that is referred to there the same one that you were testifying about earlier on, that you were referring to? I just want to confirm that.
Kinya go re netefatse taba e ke colonel o go bolelwang ka yena ke yena o a bolelang ka yena ke yena o lena le file mtlhatsi ka yena
ke tano ke yena mara something is not right because he believed that colonel mo ke bona colonel Makua.
I would just say it's him, but there's something which is not right because he was a Lieutenant Colonel Makua. Here it's just Colonel Makua.
Your Worship, it's not an objection. I know it may be perceived to be quite time wasting if I rise time and again to request.
No, you're entitled to.
Thank you, Your Worship. Your Worship, I heard that the witness said something is not right. It's still a mixture of languages again. And I am of a prima facie view that the state witness would perhaps want to use English. Maybe he's running short of certain phrases or statements in English, I don't know. But I'm just saying, Your Worship, if he would like to use English, perhaps he can use English. But I'm just saying, Your Worship, it's quite disturbing if I rise time and again to say the same thing. We understand, Your Worship, I personally understand that he may be enjoying both languages, but at least to choose one, as the court pleases.
Now, I've noted your concern, but I also have also noted that the generation of today, as they speak, they always infuse certain languages in their sentences. And I am not seeing him far different from this generation as per the perception.
As the court pleases.
But my viewpoint is, Mr. Tobejane, try your best to speak the speed. I think he's not deliberately doing it. I can see that he seems to be believing he's speaking Spanish.
Correct, Your Worship. Correct. It's not a deliberate.
English, speak only Spanish.
Thank you, Your Worship.
So, kupela gore le do yema go sepe ke a kriba ni go bolela speaking ya go bolela sekgwa le sekgwa ka monno le o lo phela ema kgafetsa le kgafetsa a re gape le a tlhakantšha kere le kwela kere Mr. Treasurer. Understood.
Thank you. You may proceed, Mr. Member.
Thank you.
Escort, please, Your Worship. Mr. Tobajan, have you had an opportunity to read through the entire paragraph 3?
Leilela khomela monyetla wa go bala yona paragraph 3 ka botlalo. No.
I'm inviting you, if you may, to read paragraph 3.
If you want to paragraph 3.
Is it not wise that you defend because you know the paragraph? Read it so that it be
Escort, please. I'll assist Your Worship.
Yes.
Paragraph 3 reads as follows. It is therefore our instructions that our client has been instructed by Colonel Makua, whose email address was provided therein, not to transfer the funds either to the bank accounts as nominated by either of you. Our client await clarification. Our client await clarification has been received in this regard from any of the reporting and or investigating authorities.
Paragraph number 3 that's like you work. Laetjwa ke yena Colonel Makua ka email address number yake gore rena re ska bara tšhelete le go banka tsona tšewe di tla ba leng lena le re diše go tsona ke re sa emetše gore ba kgone gore tlhatlhela tsaba yona yake re sa emetše botlhatse mo tabeng yona yake le reporto le ka go sa di wa dinyekišišo
Do you understand the contents of paragraph 3, sir?
Yes.
And understanding that that is what paragraph 3 says, you've testified that now you are in possession of both passports of accused 1 and 2, which suggests that they've traveled on various days. Can you perhaps assist this court as to when exactly did they travel? Do you have exact dates on their travel?
Le tlhalositse gore le tshwere di passport tsa ba babedi ba bonanelwa ke mo le mo di passport mo tse di tlhalosa ga botse gore batho ba ile ba tswa maeto ba ile ba tswa maeto a ne
a specific date.
I don't have a specific date. And then ba ku hlaya yona paragraph number 3 le hlaya go timhaka ta ku ba dzwiriwini hi vanhu va kwele kumbe xani va vutirha kwele ku va ri Colonel Makua u te loko ku ri timali teto ti nga tisiwa kumbe ku yisiwa ka account yin'wana yihi kumbe yihi ka endliwa vulavisisi ha lava ku hundza kumbe ku twisisa laya na laya loko va kulukumba va endla vulavisisi a hlahlamusela timhaka ta ku loko swi ta ka mhaka ya ku vanhu lavambirhi va nga va tikumi va huma ahandle ka tiko lera hina ra kumbe ka ahandle ka tiko ra hina va vhakela matiko man'wana swa ku hi rini a ni swi tivi.
The instructions I obtained from the accused just a moment ago is that the accused person did travel outside the Republic after receipt of this document, and that investigations will assist you in that regard.
Bari botlhatsi bo ke bo kgweditseng go yena mosexual wa bobedi ke le channel yena gana mo ba ile ba etela ka ntle ka naga tsa ka ntle ka morago ga ba seno go tsa pampiri yone yake ge ntse le tswela pele le dira dinyekišišo le tlo ikgwetša taba le no comment.
And in light
ba ku sweswo swa ku ka ndzhaku ka loko ba kumi phepha leriwani ba ve ba tikuma va ri vanhu lava va endzelaka matiko man'wana a ni na ntiyiso a ni na nhlamulo na swona.
And that despite the wording of paragraph 3 clearly dealing with investigating authorities, notwithstanding that travel, they still returned apologies. They still returned to the Republic of South Africa despite knowing about this matter.
Le ge ntse ba tseba taba tsone tse ke tsa gore ba nyekišišiwa and ba nyekišiša ke batho ba bagolo ba ile ba etela naga tša ka ntle ba fetša ba boya ntše go le jalo ba botse ba bohlatse bona boke. No comment. And then a hlamusela timhaka ta ku na hambi va kha va swi tiva ku ri vanhu lava va lavisisiwa ku ya hi vumbhoni lebyi hlamuseriwaka eka paragraph number 3 va vi va ya handle va vhakela matiko mambe kambe va tlhe va vuya va kha va swi tiva ku vona va lavisisiwa and va lavisisiwa hi vakulukumba.
You testified that an amount of 900,000 was allegedly paid by accused number 2 to one of her clients in the execution of her duties. No, apologies, Worship. I'm just confused by the way they are seated. You testified that an amount of 900,000 was paid by accused number 1 to one of her clients. If I'm not mistaken, you refer to them as the Masha family. Am I correct?
File botlhatse ba gore mosexo wa mathomo o ile a patela o mongwe wa batho ba gage e leng a patela 900,000 rands he ke sa phoši le rile ba Masha. That is correct. That is the information that I got from Masha's family. And then aku uzi uhlamusela timhaka ta ku loyi muhehli wa kusungula ku na mali leyi a nga hakela va ka Masha yi nga 900,000 rand ivi aku i ntiyiso i vumbhoni lebyi ni nga byi kuma kusuka ka ndyangu wa ka Masha.
And you also testified that the Matavata family was paid allegedly 500,000. Am I correct?
Na pele wa feta wa tlhalosa gore ba Matavata bona ba patetse 500,000 rands. Ke nnete. Correct. That is the information that I got from Matavata's family. And then in the utlhamsela kore baka Matavata uba hakeli 500,000 rands. Ebi aku swona hi leswi ni nga swi byeriwa hi baka Matavata.
In light of that, do you have any information or any evidence to assist this court in terms of when more or less were these payments made in relation to the date of the alleged offense?
Then una le botlhatsi mohlomongwe bo ka thušang kgoro eke ba go tlhalosa go botlhatsela gore go ba go šupa go ba go bontšha gore ditšhelete tše di patetswe neng kudu-kudu re lebeletse le gore molato o direteng.
Ke na go tlhatsela se fela malapa a mabedi ka moka gore ba mpoditše gore ba receive payment tša bona ka December 21.
I'm not certain about that, but these two families told me that they got their monies around December to January, or in between December and January 2024. And then ako anantiyiso wa swona sweswo kambe mindyangu leyi mimbirhi yi byeri ku mali ta vona va tikomi kwalaya ka vo December ku ya ka January 2024.
How far are you with your investigations in this matter, sir?
Litakai ka dinyekshisho ntate.
Disclose before court.
Can't disclose before the honorable court. And this court kusijela huko kunda kwi la sisi twami.
Put differently, have you investigated this claim that they've received payment? Have you perhaps done a 205 of their bank statement to confirm if there's any payment that they received, as alleged?
Barjali, lilela dira dinyekshisho na here tla go di patelo tjena tse ba bolelang ka tsona mohlomongwe la di le ngwalelela la go khopela gore le kgone go tsenela ka ra di banka tsa bona go gontsha gore ka ne di tšhelete ba ikgweditše
a se ka fihla mo ka re lapa la ga Masha ka palela go go tsena account number ba re sebilego difference go tswa gona lapa la Mathata ke
Nonyane. I did not do that because Masha's family they told me that they were unable to give me the account details or account number in which they received the said money from. Tabata's family told me last month that they received this money. All along I was not aware that they got this money. And then ako baka masha banjwele kuri abakoti kukuma account number le banga kuma mali le one le mali le ingangena ka yona, and then baka mathabata ba kunjwela muti le ngahunda ko ba kuma imali, so understand nkarhi lowu kwako.
So is it your position that at the time in which the matter came to court, the state was aware of some payments that have been received by both families?
Barjwale kana go molato o ita court ke botlhatsi ba lena ba gore ba mmusho ba ba botšhitšhisi be ba ntse ba tseba ka ditšhelete tsone tšewe le reng ba le ba ba patetšwe.
I
don't understand the question.
Is it your position, based on your testimony that you just gave today, that the state, as far as the 17th of August is concerned, was aware through you of some payment that were allegedly made to both families?
Barjwale ke botlhatsi ba lena na bo le bofang pele di 17 tša go ba ka di 17 tša August aga ba mmusho ba botšhitšhisi bentse ba tseba ka taba tša gore go na le malapa a patetšweng go ya ka se lena le ba boditšhentso.
By 17 of August, when? Which year?
2026, on inception of this matter before court.
Yes.
Ba re di 17 tša August 2026 tšatši le molato o thomileng ka lona ana ke botlhatsi ba lena ba gore ba mmusho ba ba botšhitšhisi bentse ba tseba gore go na le malapa a leng gore a patetšwe ditšhelete tša bona go ya ka mokgwa lena le boditšeng ba botšhitšhisi.
ke nna bonnete jwa seo le nna ga ke na bonnete jwa gore ba kgwetse tšhelete ke mo santse ke dire dikgopelo tša section 205.
Okay, I'm not quite certain about that, and I'm also not sure about that. It's only now that I have to make an application in terms of section 204 or 205, and then leswaku ba botšhitšhisi a ba swi tiva ku ri mina ku na timali leti nga hakeriwa mindyangu yo karhi, sweswo a na vutivi na swona. Xin'wana na mina swa ku impela vanhu lava va hakeriwi timali ta vona naswona a na ntiyiso na swona, hi kona sweswiwani ni nga ta endla xikombelo xa ku ni kota ku kuma mpfumelelo wa ku nghena andzeni ka tibanka ta vona.
Sir, would you agree then that in as much as that is an allegation that comes from the family, the state, or put differently, despite not having the evidence to support what you are saying, and I accept that you still need to investigate, have you told the NPA or the state in this matter with respect to those allegations that were averred by both families in terms of these potential payments that they received? And I ask this question in view of the allegation of the total loss that was averred on the draft charge sheet. Have you had an opportunity to discuss that amount, at least with the NPA?
Okay. Arnapili.
Your Worship, it's I don't understand the question.
Then you must repeat it.
Why?
If you do not understand.
Why I don't understand it, Your Worship, it's this. The reasons are that the charge sheet is clear that monies were transferred from the estate to Mercedes-Benz. The minute funds left the estate bank account, as per the charge sheet, that's actual prejudice.
Yes, but what is your question? What is that you don't understand? I want him to repeat.
The issue, Your Worship, is that my colleague expects the state witness to respond to what I can refer to as a highly academic issue, because this is actual prejudice the minute the account left, the money left the estate bank account. Whether accused number 1 at the later stage compensated the victims or not does not take away the fact that she paid Mercedes-Benz Vonderboom 1,750,000 rands without the authorization, without permission, to put it in simple terms, of this heirs or beneficiaries of these 2 estates, as the court pleases.
xivutiso xa dota a ni ri xi twisisi kahle hi mhaka ya ku hi swi hlamuseli kahle ku ri laya ka nandluya ku ri a swi nga ri na mhaka ku ri mali liya u vi a va hakela yona ndzhaku kumbe njhani loko yi za yi huma eka akhawunti ya munyi wa kumbe ya mufi kumbe ya lava a va fanele va yi kumaka vadyi va ndzhaka ivi yi ya yisiwa eka Mercedes-Benz, sweswo hi swoxe i nandzu, swi nga ri na mhaka ku ri u vuya yi tlherisela ndzhaku kumbe njhani.
And Your Worship, further to that, it is testimony of the state on record currently that 1,750,000 rands is still in the custody of Mercedes-Benz. If my learned colleague is asking this question, it should be taken into account the fact that Mercedes-Benz still has 1,750,000 rands, which does not belong to Mercedes-Benz, but belongs to the deceased estate. What would Mercedes-Benz do with that 1,750,000 rands? Because it's money that was taken off the estate. I'm trying to be careful not to answer on behalf of this witness, Your Worship, but I'm trying to indicate that this it's something that may be raised perhaps in argument, so that we can ventilate it from both sides. As the court
Meta swihleketa ku mali liya hi nga vulavula hi yona yi nga 1,750,000 rands yi le ka Mercedes-Benz, yi le kwele a yi le ka munhu mali yona liya. Se leswi ni ringetaka ku swi hlamusela lan'wana i ku leswi a swi vutisaku i swilo leswi a ta swi vulavula eka ndzhaku loko se vumbirhi bya hina hi ta va hi kha hi vulavula ku nandzu lowuwani swi hi vona njhani kahle loko hi ya kwele makumu.
Perhaps remember both you and the defense of the state that this is a bail application for which the guilty or innocence of the accused is not in question. The issue is the accused liberty, which has been deprived now in view of the fact that the 2 of them are in custody. That is Section 12 of the Constitution of the Republic. So the witness also, who is before court, he indicated that there are allegations of some payments or whatever, which he still is still, as per the investigation, will do a Section 205 investigation. So as of now, we could not even ascertain whether there is any payment or not. That is per the answers that he gave before this court.
That's correct.
So
that's correct.
Perhaps the court is bringing this to the picture in view of the fact that we are not to discharge the honors of the guilty or otherwise of the witnesses. It is whether the accused should be considered for bail or not.
Correct, Your Worship.
Thank you.
I was just trying to be careful not to answer on behalf of this witness when I raised it in that way.
Thank you.
Thank you.
You can proceed with your question.
Your Worship, is it perhaps for the record necessary that I respond to the issues that were raised by my colleague, or just proceed with the witness?
What is on record? Can you repeat yourself?
No, the issues that he was raising, that the funds are still sitting at Mercedes-Benz, I just thought I should place the following. We are not in dispute on that. If perhaps you can allow me to expand on why I was asking the witness this aspect. It has nothing to do with the guilt or the innocence of the parties. The aspect of the money, the principle of commissio, which I believe my colleague is aware of, well established in law, will deal with that. At this certain point I wanted to make regarding this information, and it was merely the aspect of whether or not that which just came out now from his evidence was related to the state. That's all. I needed just to know that. Okay. Because he's the one who led evidence to the effect that some payments were made. So I just wanted to confirm if he has relayed that information to the state. And I also considered that he still has to do a 205. All I just wanted to know was whether or not he has brought that to the attention of the state on inception.
I think as per his answers, he indicated that these were issues that were not yet clarified, and he intended to verify it as he does the 205 statement, so that if he has to give an answer, he will be able to give such an answer with certainty. But as of now, he said there were issues of that nature.
Yes, I concede that, Worship, but my question was merely on simple basis whether he relayed that to the state. That was all, the allegation that he has received only. But for the sake of progress, Your Worship, we may...
You may proceed.
Yes. Mr. Tobejane, let's deal now with the crux of why you believe that accused number 1 and 2, if released on bail, will potentially commit further offenses. I put it to you that prior to the arrest, we can agree that, let's deal with the 17th of August 2026. Prior to the first appearance on this matter, both accused 1 and 2 have never been arrested on any other matter, and therefore there is no history or propensity that can be demonstrated that previously they committed offenses. What do you base your argument that there is a possibility of them committing further offenses? Is there something that motivates what you are saying?
Napile bare a re tle mo go tabeng ya gore mosekshwa mathomo lo bobedi le re ha ka lokulwa ka bail ba ka lokulwa ka bail ke batho ba ngore ba ka dira melato e mengwe ba le ka kwa ntle ka bail a re tle ka taba ye ya di 17 tša August 2026 ye le boletseng ana motho ba boletse gore go tlhalositswa gore ba go na le botlhatsi ba go bontšha gore batho ba babedi a gone melato e mengwe le gore ba sa itsamaela a gone botlhatsi ba go bontšha gore batho ba nkile ba ba le melato jwale lena taba tše le di bolela le ditšea kae goba le kithegile kang ka taba yeo le bolelang kana motho ya gore ge ba ka lokolwa ka bail kgonagalo e gona ya gore ba ka dira melato e mengwe.
In my worship, Waka profiling Yaka, a case number 2, Aswara before, before Aswara.
According to my profile, accused number 1,
so
accused number 2 was once arrested. He was once arrested. He once committed an offense. Then kuya hi vulavisisi bya mina kumbe lebyi byo lavisisa munhu la ya hi languta ku na u tshame a endla nandzu na ku ya hi nawu, and then loko ni languta laya swa hlamusela kumbe swi tsariwini ku ri loko ri muhehliwa wa vumbirhi u ze endla nandzu a khomiwa.
And do you have any information as to what transpired to this alleged offense?
Then lena le botlhatsi ba gore go diagetseng ka molato o feletse kae?
Molato it
was withdrawn. It was an assault. Nandulu ya babe ba wa sola a go nandu o ba munhu.
Do you have any evidence that suggests that besides this offense which was withdrawn, there are any other matters that accused is facing?
Ba jwale ka ntle ga molato ona o nkile wa phumula lena le botlhatse ba go bontsha gore o na le melato e mengwe.
I cannot
No, I don't have. handle ka nandzu loyiwani wu nga suriwa ni hava vumbhoni byin'wana byo komba ku ku na milandzu yin'wana.
Do you have any evidence to suggest that a degree of violence was displayed in the commission of this so-called the current charges that they are facing, that there was any violence allegedly during the commission of this offense?
Ba re jwale gona mo melatsong e ba pharwang ka yona lekgono le na le botlhatsi ba go bontšha gore ge wa dira melatso yona eke go ile ga šomišiwa taba tsela tša dintwa goba gona maatla goba gona go iša motho o mongwe botlhoko. Don't have such evidence. And then anna vumbhoni byo komba ku loko ku endliwa milandzu leyiwani va nga va va tirhisi matimba kumbe wona madzolonga.
Do you have any evidence that suggests that accused number 2, considering that you say in his profile that he was arrested before, that he ever violated his bail conditions there?
Jwale le na le botlhatsi ba go bontšha gore mosekišwa wa bobedi ka gore le re nkile a tshwarwa akere ba go bontšha gore yena nkile a se tlhomphe melao ya bail.
Kana botlhatsi jo ka ge ke sa tsebile gore o kile a ya bail or not.
I don't have such evidence because I don't even know whether he was released on bail or not. And then anna vumbhoni va swona sweswo swa ku loko a ka nandzu loya kumbexani va nga va ku va tema ka nandzu loya ku ri u chuchiwe bail kumbe a nga chuchiwangi bail, swa ku a nga va a ri munhu loyi a nga tlula milawu ya bail.
Do you have any evidence that either accused 1 or 2 ever violated any conditions imposed upon them by a court of law?
Jwale le na le botlhatsi ba go tlhatsela gore bobedi ba sekišwa bana ba kinkile ba tshela melao ye ba tla ba filweng ke kgoro e tseng.
Nka se be le botlhatsi jo ka gore a ke tsebe gore gore e fo ba fikile ya ba fa o ta go ba eng.
I won't know about that because I don't even know as to whether there's a certain court which once gave them a certain conditions. Ni nge swi tivi mina sweswo hi mhaka ku a ndzi ni swi tiva ku ku na huvo leyi kumbexani siku rin'wanyani leyi hi nga va nyika swipimelo leswi vona va nga swi tlula va nga swi landeli.
Do you have any evidence at all before you that suggests that either accused 1 or 2 has previously undermined the objectives and the proper functioning of the bail system?
And then le na le botlhatsi ba go tlhatsela gore basekišwa ba babedi mohlomongwe ba ile ba nyata tshepedišo ya melao ya bail. Go na le mo nkile la really dia di-profiling tša lena la hwetša ba re ba babedi ba ile ba batho ba leng gore ba nyaditše tshepedišo goba gona o se ba emele melao ya yona bail. Go na le mo le na le botlhatsi ba selwe ba re le a mbušišo re ra gore ba re le na le botlhatsi ba go bontšha gore ba babedi tšatši le lengwe kae mafaseng ba ile ba batho ba leng gore a senke goba ba ile ba nyata tshepedišo goba melao ya bail.
My worship, bail ya fa motho ba mo tshwereng. So ga ke ke boletse gore a case number 1 a se ke ba mo tshwara, case number 2 ba mo tshwara one, so ka se ba lete bail ba se ke ba go tshwara.
Your worship, as I've already indicated that only a person who's been arrested can be granted bail. So as I've already indicated that accused number 1 was never arrested, accused number 2 was arrested once.
So what makes you think that, and I'm inviting you to comment if you can, if you can't it's okay, what makes you submit that I mean, based on all the answers that you've just given, there is no history of any evasion of trial by accused number 1. There is no history of undermining the bail system. I mean, all the elements that are required to be satisfied, which she alleges, there is no history of that. What makes you believe that all of a sudden, if she's released, these kind of things will occur.
But usually, ka gore lena a lena botlhatse ba go bontsha gore motho ke motho le gore a ka lokula ka bail a ka tshaba ke motho le gore a ka se obamele melao ya bail jwale ke eng se se dirang gore lena gare ga sebaka-baka le donaka le thome le be le kgopolo ya gore ga a ka lokulwa ka bail a ka tshaba
mayoshito ka ke boletse ke re a bona go ka hutsa bail ba se ke ba go swara that is why go sena history because a se ke ba go swara.
Worshippers have already indicated that there's no way in which we can have such information of bail because she was never arrested. That is why we don't have it.
Accused number 1 had submitted in her affidavit or the testimony before this court that if she was to be granted bail, she proposes to provide you with what you call a live location on a WhatsApp at any point in time if you so require her. What's your comment to that?
Napile musexual matom wile argabulela mole a fa botlhatse go ba ka tsela ya affidavit a riena o ikemisheditse gore wena a ka go fa a go ba go tsibisha gore yena o kaina o maneng se le re se butsang gore ke yona live location ya WhatsApp ra gore o kgona mmona motho gore ngane jwalo o kae wena o re ka taba tšeo
ke dumela le sewe ka re ga paletse go se dira ka ra go hlano ba fitela mante a Sharpo police station.
I do not agree with that because she failed to brought herself from
17 August.
From 17 August.
Complete location ya roka motomaga 17 I mean 14 August that is wara case number 2.
Requested her live location or I requested her location from the 14th of August when I arrested accused number 2.
Location
she refused to give me her location until Monday when I arrested her. And then session fumelana sona swa ku yena u ta endla timhaka leti ta ku ankomba ku ri yena u le eka nkarhi n'wana n'wana leswi swa ti WhatsApp swi swo komba ku munhu u le kwihi sweswiwani nkarhi muni a ku sweswi a ni pfumelana swona hi mhaka ku u tsandzeki ku swi endla hi ti 14 ta August loko ni n'wi byela ku ri ni byeli ku wena u le kwihi a ala na ntiyiso ya ku yena u le kwihi ku fikisela ni ta n'wi khoma hi Mvhulu hi ti 17 ta August.
Your Worship, I've noted that accused number 1 is trying to reach out for my attention. May I approach her?
Yes.
Based on what you are saying is your position regarding the issues of the WhatsApps that she allegedly refused to share location with you, my instructions are that, as already dealt with earlier on, arrangements were made by her legal team, which she already testified upon during her submission of a bail affidavit, that at the end of the day, you arrested her on the basis of that particular arrangement which she honored to bring herself as per the proposal that was forwarded to you, and she actually availed herself at the police station on Monday morning for you to arrest her. There was no need for any of that to be shared because in any event she availed herself to you.
Napile ba tlhalosa gore taba ye wena o reng o ganne go botsa gore yena o kae go ba yona go sharela yona live location ya WhatsApp ba re jwale ye we a isale taba ye le gore ka re ke taba go mo tabeng ke ka gore ibe a setse a boletse wena a boletse taba ya gore ke tlo ke tlisha ka Mantaha and a feletsa a ke tlisitse ka Mantaha jwale ye ya gore wena o tsebe go mo kae be isa le botlhokwa ka be sitse go boletswe gore motho o tlo ke tlisha ba bo sitse na le kwano ya gore motho o tlo ke tlisha
a senke ka ba le kwano le na gore a tlishe police station nka be ke go kwano le ne ke gore a ye nearest police station. That is why we are ship we are not losing to WhatsApp or legal representative accused number 1.
I never had any agreement with her. If ever I had one, I would have told her to go to the nearest police station. That is why you, referring to the attorney, you sent me the WhatsApp informing me that you are the legal representative for accused number 1.
Just to clarify, you say my officials or colleagues are the ones who reached out to you for purpose of that arrangement, which was provided to you in writing, not me personally.
And then ako look yena antabani nguzwile kure afambi aya report a police station yelo kusuhi himaka ku mina anibanga nantwana na yena ene hikwalaho ka ku wena gqwetha ra wena ubuheta unrhumela na WhatsApp ivi akulungisa sweswo rhumeliwa nge mina WhatsApp yaleyo rhumeliwe hi vatirhi na mina.
So because you have brought that issue to the attention of this court, the question then is, notwithstanding your resistance to the aspect of WhatsApp, are you disputing that when such communication was made to you, which there's nothing in law, by the way, to make that kind of arrangement with the officer to hand over a suspect, are you saying that when that proposal was placed to your office, you still faced resistance to apprehend accused number 1? Are you saying that she never came based on that particular arrangement that was then made?
Then Barry, lere banning lena le ganetsana le dira batho mo tsa WhatsApp wa ke then ka hore yena lena le sa ganetsana le sa re motho o ganne go tshwara le re mo re yena motho o ile a ba yena ke tlisang di office tsa lena we ya ka mpo go kwanetseng ka go
a ke pushise position.
I don't understand the question.
Stojan, I'm saying in light of the fact that you are referring to this aspect that she failed to give you a WhatsApp, and our instructions are that notwithstanding what you allege that she failed at the time where there was no court order that she must do so, she in any event made means through her attorneys to inform you that she's going to hand herself over, and indeed, true to that arrangement, she brought herself over to you.
Barizole, Mr. Tobejan, le baning yena, le baning yena, ke neta ka le baning ke neto go ganne gore go le botsa gore yena o kae o mo kae ya ka le baning ga gapeletse ke selo go le botsa gore mo kae ya ka then yena a ke yena o le ba yena a ke o ile a feletsa a dira dipoledišano le memedi wa gage a bolela le lena ba le tsebiša gore